21st of the public back in session. Honorable Peter J. Wadle presiding.
You may be seated. Mason County Circuit Court is now in session. We'll take up file 1-5-2952 People of the State of Michigan versus Sean Phillips. Phillips is present, represented by Attorney David Glancy. Also present is Prosecutor Donna Pendergrass and Prosecutor Paul Spagnola. The matter is here set for sentencing today. The record should reflect that the court has received the pre-sentence investigation report, People's Sentencing Memorandum, 3 letters addressed to the court. First question is, Counsel, have you had the opportunity to read and review the pre-sentence report? Ms. Pendergrass.
Yes, Your Honor, I have.
Mr. Glancy.
Yes, Your Honor, I have received the pre-sentence investigation report. I've had the opportunity to review that and also met with Mr. Phillips at the Carson City Correctional Facility and had the opportunity to review that report with him as well.
All right. And first question for the prosecution, do you have any challenges to the accuracy or relevancy of any information in the report?
I do not, Your Honor.
Mr. Glancy, do you have any challenges to the accuracy or relevancy of any information in the report?
Yes, thank you, Your Honor. First would be on the issue of jail credit. We'll be asking that the credit for time served actually be 1,991 days, which would be from the date of his original arrest back June 29th of 2011. I know that this matter was brought up in the People's Sentencing Memorandum, arguing People v. Riesbeck. That case was a larceny, or originally the individual in that matter was charged with a larceny by false pretenses. There was about 6 victims. They were sentenced to 360 days. Later was charged with racketeering, given numerous additional victims, and that case held that the defendant in that, Riesbeck, was not and should not be given credit for those 360 days originally. I think that's different from the current case that we have. We have the exact same facts, the exact same victim. The only change from the date of arrest in the unlawful imprisonment case to the current matter was the statement allegedly to Mr. Burton, and then the letter that was written by Mr. Phillips. Other than that, all of the facts and evidence have remained the same, and my client has been incarcerated since June 29th of 2011. I would ask the court to give him credit for that entire time.
Do you have any specific case law that interprets when the credit is to be given?
No, Your Honor, just the statute and then the current case that was cited in their memorandum.
In my review of this matter, I recognize that this case arose out of the same facts and circumstances as the prior case. What I can't find is specific authority that tells me whether the credit to be given should be back to the date of his original arrest on the original matter or back to the date of his arrest on this matter. I'm inclined to agree with the prosecutor on this matter and to go with the interpretation of Riesbeck, and therefore I deny the request for credit back to the date of arrest on the original matter. Do you have any other challenges to the accuracy or relevancy of
I think you're on page 7 under the precinct investigation under employment. I believe that it should be noted there that Mr. Phillips is also in the National Guard from 2008 to 2011.
And where are we on that report?
That would be on page 7 under the precinct investigation, Your Honor,
Okay.
under the caption of employment.
So you would add
I would ask that be added to that section.
employer National Guard. Any objections, counsel?
None, Your Honor.
Mr. Schumer, please add that to the list of his employment and correct your pre-sentence investigation report to reflect.
Yes.
Is there a next matter, Mr. Clancy?
Thank you, Your Honor. One other just minor correction before scoring issue is on the last page of the sentencing information report. That has the judge listed as Honorable Susan Smigalski. That should be corrected to your name, Your Honor.
Okay, I missed that. Last page.
Yes, the sentencing information report. The second line on that.
Second line,
At the top of the page, it says the judge in that matter.
the judge, yes, that would be corrected, Mr. Schumer, to reflect that I am the judge in this matter. And my bar number, if you need it, P23335. Any further challenges, Mr. Clancy?
The next one would be to the scoring guidelines of prior record variable of PRE 7, which is subsequent or concurrent convictions. In this matter, it sort of relates back to the credit for time served, but it appears that the people are trying to, I mean, for back of what terms, have their cake and eat it too. We have not giving credit from the date that he was originally arrested. And the reason for that is because he wasn't charged for this murder until 2013, which, given the 2-year gap, that doesn't really make it subsequent or concurrent, but they're scoring that as well. And I don't think that they should be allowed to score PRB 7 as subsequent and concurrent if we're arguing that he wasn't charged and with that matter for 2 years after he was already charged and convicted of the unlawful imprisonment. So I actually think that it should either be scored at 0 points and then no credit for the time that he sat, or in the alternative, scored at the 10 points but given credit from the date of sentence.
Ms. Pendergast.
Your Honor, just briefly in response, I think the case law is clear. There is a concurrent felony conviction. The fact that the murder wasn't charged until sometime later, we're talking about the same fact pattern that happened on June 29th of 2011. I think it's appropriately scored. I think it would actually be reversed by the Court of Appeals if it were not scored. The scoring is appropriate, and I would defer to Mr. Schumer if he has anything to add to that. It's standardly scored, Your Honor.
Yes, well, I reviewed the prior record variable, the statute, and the language, and had he been charged with both matters, 2 felonies, and convicted at the outset for both matters, there would be 2 concurrent. The approach that is taken here is this is 1 subsequent or 1 concurrent felony conviction. Concurrent is the argument the prosecutor is saying, because it arises out of the same facts and circumstances, even though it's not concurrent in the sense that it's temporarily, that is, at the same time concurrent. I find that it is appropriate that this matter be scored 10 points, and I deny the objection on this front. The prior record variable, total of 15 prior record variable of C are accepted.
And the last challenge, Your Honor, would be to OB5 regarding serious psychological injury requiring professional treatment occurred to a victim's family. The fact that treatment has not been sought is not conclusive. However, in this matter, both in the pre-sentence investigation report on the original offense and the unlawful imprisonment, that variable was not scored. And there was no objection to that on the record by the people at that time, nor appealed. That was scored at 0. I believe that this one should, OB5 should be scored at 0 as well. There has not been any testimony to any counseling, and although that by itself is not conclusive, there was no testimony that the mother is suffering from depression or any other matters. In fact, her testimony at the trial was that she was doing well, I believe, to finish her schooling, in a new relationship, had a job, a new child, and I don't believe that OB5 should be scored at 15 points, but at 0. In the sentencing memorandum, they argue that this is a circumstance under which a reasonable person should seek counseling and mandates the scoring of this is a serious psychological injury. However, that's not what the definition or the requirements are in the sentencing guideline manual, and would ask that that be appropriately scored at 0 as it was in the prior matter.
Ms. Prendergast.
Your Honor, I would suggest to this court that I can hardly imagine a more psychologically trans and continued state of limbo, for lack of a better term, in knowing where their child is and what actually happened to their child, not only for Ariel Brewer, but for Haley as well, baby Kate's sister. I would also suggest to this court that not only was a psychological injury placed upon Ariel, Haley, quite frankly, the defendant's family as well. Judge, I would suggest to this court that whether or not Ariel Cortland ever sought counseling is not controlling, because there are going to be many, many circumstances in a myriad of fact patterns where a person fails to, is not able to, or chooses not to seek psychological counseling. But I can't imagine a fact pattern that is more compelling for a person to choose that route. I would also suggest to this court that despite the letter that was given to the court by Ariel Cortland that she has not sought counseling, that is not my information. Detective Kenny is sitting in the courtroom. He has been somewhat of a confidant to Ariel over the years. She did seek counseling at a point in time, subsequent, I believe, to the sentencing on the first case with Linda Koch. Her and Haley both actually had talked to her about different various issues. Judge, the uncertainty, the psychological trauma, and the situation that Ariel found herself in, not only as a result of what the defendant did to baby Kate, but as a result of being blamed by the defendant for being the person responsible for this horrific fact pattern and scenario. I would suggest to this court that 15 points is appropriately scored. Thank you.
Well, is that one that I score, or is that one the jury has to find in the jurors under the rules under Lockridge?
The jury does not find that, Your Honor. That is not my understanding.
The jury, it must be this offense variable be determined using facts found by the jury or admitted by the defendant?
Your Honor, I am aware of no case law whatsoever that requires or would, I can't imagine a fact pattern under which a jury would make a determination in that scenario. And quite frankly, the jury being limited to deciding this on a second degree as opposed to a first degree murder scenario, we don't know what the jury thought on that fact pattern, but I would suggest to this court that it's appropriately
So
scored.
you think Lockridge doesn't apply
Lockridge apply in what capacity?
to determining that each offense variable?
I believe the
scored,
court, I'm
that
sorry.
each offense variable that's scored must be found by the jury beyond a reasonable doubt.
Your Honor, I find that the jury found that the defendant intended to kill, intended to do great bodily harm, or created a situation with an intent to create a situation with a risk of high death or great bodily harm. I think those facts in and of themselves, inherent in those, are that whatever he does to a small child of tender years creates a situation where whoever suffers as a result of the defendant's actions clearly should seek some sort of psychological counseling.
Any further, Mr. Benson?
Your Honor, just that I do believe that there needs to be, not necessarily found by the jury, but there does need to be excuse me, some evidence to support that finding. That wasn't scored in the prior pre-sentence investigation under the lawful imprisonment. That was over a year after this matter had occurred. And as I stated before, that was not challenged or raised at that time or appealed. And I again believe that there's nothing to support the scoring of that variable today.
Well,
May I respond to him briefly, Your Honor? What I would say to that is, what the jury was assessing in that case and what was being scored in that case was the depriving of the child, or the unlawful imprisonment, the defendant's actions in depriving Ariel Cortland of her child and removing that child, not the fact that he actually killed and inflicted bodily harm on that child.
What I find with this variable is that it's the court's responsibility to make a determination, and it is not mandatory that in every homicide, if you follow the prosecution's position, this would always be scored as 15, but that is not the way this variable is. In fact, this variable would have as its consideration two options: serious psychological injury requiring, or even if not sought, that it would require serious psychological injury requiring professional treatment, or there's no serious psychological injury requiring professional treatment. The court finds that the evidence presented in this case and the information available to the court does not support a finding of serious psychological injury from which this court would score that as 15 in the case of the defense in this matter, and orders that be scored as 0, and which would reduce the offense variable by 15 points to 85. Any further objections, Mr. Lansing?
No, Your Honor.
Reducing that to 85 reduces that to an offense level of 2. Is that correct, Mr. Schumer?
That's correct, Your Honor.
So the level we're dealing with is C2 rather than C3. Please correct the pre-sentence report to reflect the determination that this offense level is a level 2. Now, Ms. Prendergast, are there anything you want this court to know before it proceeds with sentencing?
Yes, Your Honor. Your Honor, there is no statute of limitations on the crime of homicide in our criminal justice system, and there is a reason for that. The reason for that is because our society in general and our criminal justice system recognize, and society itself recognizes, the paramount importance, sanctity, and value of a human life. As human beings, from the time we're very small, children really, as soon as we're able to understand, we're taught that babies are precious, that babies are vulnerable, and that we must protect them. When I was 13 years old, I had the responsibility almost on a daily basis of caring for an infant. And there's two things that I knew for sure at 13 years old, and that was, number one, that that infant's very life was entrusted to my care, and number two, that I certainly was under a duty and a responsibility to do nothing to hurt that child. The defendant is in your courtroom today because he made a series of conscious choices. I know when the court dismissed the first-degree murder case, you said something to the effect of, young people find themselves in these circumstances all the time, and it doesn't mean that they planned or deliberated. Well, the converse to that, Judge, is that, yes, young people find themselves in these circumstances all the time with unplanned pregnancies, perhaps in the defendant's case, unwanted pregnancies. But plain and simple, he's in this courtroom and they're not, because he made a conscious and deliberate series of choices that other people didn't make. Plain and simple, he didn't want another child, he didn't want the responsibility of another child, and he made a decision to eliminate the life of a human being, a baby who had no ability whatsoever to stand up or fight back. And in our society, there are ramifications to the choices that he made. Judge, I know that the sentencing range has just changed as a result of you not accepting psychological injury, but I would suggest to this court that that doesn't really matter, because I am asking you to exceed any sentencing guidelines, which are in fact advisory now under Lockridge. The defendant is not a person who did not know what he was doing. He was young, yes. However, might I remind this court that this individual was an adult with adult responsibilities, and taking care of a baby was not unknown to him. He had a child that was nearly 3 years old at the time baby Kate was murdered. The defendant was well aware that a baby's life is entrusted to that of an adult in every aspect of their being, and he had dealt with that on a prior circumstance for over 3 years. He was an adult who was entrusted with the responsibility and was going to be deployed to defend our country. This isn't a 15-year-old kid who just finds out. He knew about it. He knew about it when Ariel became pregnant. He wanted Ariel to abort the baby. And I understand there's a very unusual set of dynamics here. You have the baby's mother who has deep feelings and cares for the defendant, her first boyfriend. And now it's, she makes statements to the court, we need to move on, he's a good person. But everything I've seen in asking this court to mitigate a sentence for Sean Phillips talks about, well, Larry and Kim don't deserve this. Well, you know what? They don't. And the unfortunate part of this whole fact pattern is the facts or the situation and scenario that Larry and Kim, the defendant's parents, and Ariel have been put in is not something the criminal justice system put on them. It is a result of the defendant's actions. What Larry and Kim and Ariel and Haley, what they deserve or don't deserve, that cannot be a part of this court's consideration. Because once again, we didn't put them, we being the prosecution and the criminal justice system and law enforcement, we didn't put them in that situation, the defendant did. I would suggest to this court that another factor that the court should take into consideration is when the defendant did what he didn't just hurt Ariel, he didn't just hurt Haley, he didn't just hurt his parents, he hurt this community. The community of Mason County and Ludington specifically, this community, a psychological injury was inflicted on this community, and it was a severe one. You had hundreds of community members, law enforcement members, frantically looking for this baby when time was of the essence, or so they thought. You have the defendant's deliberate, once again, and I'm circling back to this, statements saying that Ariel Cortland was responsible for this, which was basically thwarting the ends of justice, and not only that, but inflicting a further psychological injury on Ariel, one that I'm not sure she's over today. I would suggest to this court that she has had to live for over 5 years with a cloud of suspicion hanging over her head. Not only did the defendant show a callous disregard for pretty much everybody but himself, But I would suggest to this court, by planting the note in his jail uniform suggesting this false adoption scenario, he caused this community to spend an infinite, probably non-calculable amount of resources trying to track down whether or not there was an adoptive family involved, etc. Judge, he even bragged about it later, making the statement that he made to Rashawn Burton, "Oh, well, they can never charge me because they'll never find the body." I would suggest to this court that the harm that the defendant has inflicted not only on his family, not only on Ariel, but on this community as well, should all be taken into account. My brief and my recommendation remains the same. I would ask the court for 40 to 75 years. Thank you.
Mr. Glancy.
Thank you, Your Honor. I believe that what we have here is, in looking at their sentencing memorandum, the request for sentencing to exceed guidelines. They're arguing that they should depart above or below because this is a worst case scenario. And they refer to another case in their memorandum, but I don't believe that that is what we have here in this matter. I believe that the arguments that were made by the people in this matter are covered by the sentencing guidelines. The issue that there was a false adoption letter written, that is scored under, I believe, OV 19, and that is taken into consideration. Everything that came out of the trial, I believe, is appropriately scored pursuant to the guidelines. I believe that a sentence within the guidelines meets the requirements of giving an appropriate sentence for all of the facts and circumstances of this matter. It would deter others from committing a similar crime. It protects the public. I don't think we have someone here that is a great risk to the public. And I think we have somebody here that at the time was 21 years old. His actions were, based on the jury's verdicts, were not appropriate. They resulted in the death, whether that was an intent to kill or place somebody at risk of great bodily harm or a disregard for his actions. We don't have that separation of why they came to a second-degree murder conviction. I think that based on the letter that was provided, referred to as the admission letter, that it could be that there was a disregard that his actions could result in the death of a child. I think that is a very reasonable position given the letter and the statute for second-degree murder. I think that there is no need to depart above or below guidelines. They're arguing that he has not shown remorse or indicated where the child might be, and that's a reason that the court should exceed guidelines as well. However, I think that the letter does indicate some remorse. It also shows somebody that is remorseful, confused, scared, but we also have his right to remain silent and not have that used against him, and to exercise that right, and also his appellate rights in this matter. And so I think that saying that he's made no statements and trying to hold that against him is a reason to exceed guidelines is inappropriate. So I think that he's following the advice of his counsel, appellate counsel in this matter that was previously representative, and that should not be used against him. The testimony that we have is that he was a good father to Haley. He was a high school graduate. He was a member of the National Guard. I think that a sentence within those guidelines, which are now 15 to 25 years, is appropriate. I think that we have a young individual that when he does get out of prison, that he can be a productive member of society, that he can be rehabilitated. And I think that a sentence within those guidelines is appropriate given all of the evidence and facts that came out at the trial here.
Mr. Phillips, is there anything you wish to say on this matter? You have the right to speak or not as you may choose.
Not at this time, Your Honor.
Cortland, you have submitted a letter, you're not required to speak to our victim that has the right to be heard. Do you wish to be heard in this matter, beyond the letter that you have written?
Not beyond the other.
This is a case that is a tragedy on so many levels. I have listened carefully to the evidence in the trial of this matter, to the evidence in prior hearings on this matter. The one thing that has come through is that the ultimate tragedy is that which is visited upon or is the fate of Catherine Phillips. Prosecutor is right, Mr. Phillips, that as a father, as a parent, even though you were not determined fully to be the parent at that time by any DNA testing, you still had ample reason to know that that child was your child because of the conduct and the intimacies that you were engaged in with Ariel, and because you had another daughter with Ariel. It's not lost on this court that you and Ariel were way too young to have any children, but because you did, and Ariel was at that point so young and insecure that you had to rise to the occasion and take care of your older daughter, and you did so as Ariel grew up to be a more responsible adult. In the process of reaching that point, which had not occurred by the time of the birth of Catherine, then Ariel and you were still, truthfully, not fit to be parents. Having said that, Ariel was stepping up to the responsibility, somewhat slowly, but she was. And it came across that she was trying to get you to step up to that responsibility, but you were resisting. Prosecution's right that you had a duty to protect and care for Catherine. You had a duty to care for and protect Catherine even if she were not your child, because it's part of our social structure that every child is that is in our care is to be cared for and protected, and we're not to put them in harm's way. Now your letter, I guess there's two letters. Your initial letter, which diverted attention, but the second letter, which is the one that I think probably gives us the closest indication of what happened, can be read in a couple ways. And the prosecution took the case to the jury on the grounds that that letter created, that demonstrated that you created an unreasonable risk of harm in your actions with baby Catherine. And the jury so found that you put that child in harm's way by your actions such that it resulted in her death. I did and I do to this day tend to believe your letter that you were instantly appalled and remorseful at what had happened. I also believe that you simply didn't know what to do, and that came across in the letter. I cannot imagine that you started out intending to kill that child that day because you went to the hospital to get your blood test. If you were thinking about killing that child that day or at any time, there's no way you would have gone to that hospital to get your blood test. I But I see a young man of great immaturity, unwilling, unable to accept all the responsibilities of life that come from making children. And that was the state that you were in at that time. And when this event occurred that you caused your death, you didn't know how to handle that situation, what to say, what to do. You made another bad choice because you seem to think that if I place this child in the woods, this baby, this corpse, that this thing is all going to go away. I don't think that that was clearly thought out, but I think that's the process that you were going through. Leading up to, my goodness, you show up at your house and divert attention by saying Ariel was the one who had the child when you had the child's clothes in your pocket. I have watched you hear and listened to the arguments that the parties have set forth, and the one thing I do find, and I do believe about you, Mr. Phillips, is that you're not an evil person. I didn't find anything in your history that shows that you are an aggressive person or a predatory person, that your prior criminal history is de minimis. Not of any moment or any concern to this court. I do agree that you've demonstrated tremendous immaturity, and that's what led to this situation. So for that, it's a tragedy. It's a tragedy for Catherine ultimately. It's a tragedy for Ariel, as it would be for any mother. It's a tragedy for you. And certainly it's a tragedy for those who have loved you, have come to love Ariel and love Haley. In that respect, I'm clearly speaking of your parents who are young. I recognize that you would love to see the clock turn back, but obviously no, that can't happen. So what we do now is we respond to your actions and your conduct and to the fact that the jurors found you guilty of second-degree murder. This court is mindful that the sentencing guidelines are merely advisory, but this court does take those guidelines into consideration in rendering its verdict for today. I order that you serve a term of 19 years to 45 years with the Department of Corrections. I'll give you credit for time served from October 4th, 2013, which I believe is the date of the arrest.
That's correct, Your Honor.
I ordered you to pay the state cost of $68, and the victim's fee of $130, and a DNA fee of $60 to be collected through the inmate account for all process. I order the sentence to run concurrent with the sentence you're currently serving under Mason County docket number 11-2427-FH. Are there any additional matters I have to deal with other than the appeal rights?
Nothing at this time, Your Honor.
No, Your Honor.
Mr. Phillips, you've been given a copy of your appeal rights. And you're entitled to appellate review of your conviction and sentence. If you're unable to afford an attorney, I will appoint an attorney to represent you on appeal. You must make this request within 42 days. I'll ask that you sign acknowledging that you've received the form, and then again, if you wish to appeal, you must do so within 42 days, or proceed with completing and returning the form to the court within 42 days after today. Any further counsel?
Nothing at this time, Your Honor.
Further counsel?
No, Your Honor, thank you.
Thank you, Your Honor.